I dare you to fix me.
Rule 129. What need to be proved? Mandatory judicial notice. Section 1. Judicial notice when mandatory. A court shall take judicial notice without the introduction of evidence of the existence and territorial extent of states, their political history, forms of government, and symbols of nationality, the law of nations, the admiralty and maritime courts of the world and their seals, the political constitution and history of the Philippines, the official acts of legislative, executive, and judicial departments of the national government of the Philippines, the laws of nature, the measure of time, the geographical divisions. Judicial notice is the cognizance of certain facts which judges may properly take and act upon without need of proof. It is based on considerations of expediency and convenience and displaces the necessity of evidence on a settled matter to save time, labor, and expense in introducing such evidence. It displaces evidence being equivalent to proof. Judicial notice fulfills the objective which evidence intends to achieve. Note, judicial notice is not equivalent to judicial knowledge. A fact may be of judicial notice and not of a judge's personal knowledge, and vice versa. Judicial notice fulfills the objective which the evidence intends to achieve. It is the cognizance of common knowledge. Judicial knowledge is that which is based on the personal knowledge of the court. The following need not be proved: immaterial allegations, number two, facts admitted or not denied, provided they have been sufficiently alleged. 3. Agreed and admitted facts. 4. Facts subject to judicial notice. 5. Facts conclusively presumed or disputably presumed but uncontradicted. Matters of mandatory judicial notice. 1. Existence and territorial extent of states. Number 2. Their political history, forms of government, and symbols of nationality. Number 3. Law of nations. 4. Admiralty and maritime courts of the world and their seals. 5. Political constitution and history of the Philippines. 6. Official acts of legislative, executive, and judicial departments. National government of the Philippines. That's in the new rule. 7. Laws of nature. 8. Measure of time. And 9. Geographical divisions. The law of nations is the compilation of rules which, by common consent of mankind, have been acquiesced in as law. Foreign municipal laws, general rule. Foreign laws may not be taken judicial notice, and they must be proved as any other fact. They do not prove themselves, nor can courts take judicial notice of them. They must be alleged and proved. They may be evidenced in accordance with Section 24, Rule 132 of an official record. Exceptions: foreign statute accepted by the government. Number 2, common law. Question: suppose a foreign law was pleaded as part of the defense of the defendant, but no evidence was presented to prove the existence of said law. What is the presumption to be taken by the courts as to the wordings of said law? The doctrine of processual presumption applies. The presumption is that the wordings of the foreign law are the same as the local law. Doctrine of processual presumption. Northwest Orient Airlines versus CA. Doctrine of processual presumption lays down the presumption that the foreign law is the same as the law of the forum. It arises if the foreign law, though properly applicable, is either not alleged, or if alleged, is not duly proved before a competent court. When parties in a case agree on what the foreign law provides, these are admissions of fact, which the other parties and the courts are made to rely and act upon. Hence, they are stopped to subsequently take a contrary position. Philippine Commercial and Industrial Bank versus Escalin et al. GRL 27896. Discretionary judicial notice. Section 2. Judicial notice when discretionary. A court may take judicial notice of matters which are of public knowledge or are capable to unquestionable demonstration or ought to be known to judges because of their judicial functions. A court may take judicial notice of matters which are 1. Of public knowledge, 2. Capable of unquestionable demonstration, or 3. Ought to be known to judges because of their judicial functions. Requisites of judicial notice. 1. The matter must be one of common and general knowledge. Number 2. It must be well and authoritatively settled and not doubtful or uncertain. And 3. It must be one which is not subject to a reasonable dispute in that it is either 1. Generally known within the territorial jurisdiction of the trial court, or B. Capable of accurate and ready determination by resorting to sources whose accuracy cannot reasonably be questionable. Note, the principal guide in determining what facts may be assumed to be judicially known is that of notoriety. The test of notoriety is whether the fact involved is so notoriously known as to make it proper to assume its existence without proof. There must be unconditional acceptance by the public or the segment of the public where the fact is of relevant importance. The fact that a belief is not universal is not controlling, for it is seldom that any belief is accepted by everyone. It is enough that the matters are familiarly known to the majority of mankind or those persons familiar with the particular matter in question. Republic versus CA GR 54886. When is a matter considered common knowledge? There are those matters coming to the knowledge of men, generally in the course of ordinary experience of life, or they may be matters which are generally accepted by mankind as true and are capable of ready and unquestioned demonstration. Note, thus, facts which are universally known and which may be found in encyclopedias, dictionaries, or other publications are judicially noticed, provided they are of such universal notoriety and so generally understood that they may be regarded as forming part of the common knowledge of every person. A court, however, cannot take judicial notice of any fact, which in part is dependent on the existence or non existence of a fact of which the court has no constructive knowledge. Expert Travel and Tours versus CA, GR 152392. Judicial notice of records of another case previously tried. The general rule: courts are not authorized to take judicial notice of the contents of the records of other cases, even when such cases have been tried in the same court and pending before the same judge. People versus Hernandez. Exceptions: 1. When at the initiative of the judge or of the parties and without objection of any party, the records of the previous action are read and adopted into the present action or attached to the records of the present action by court order. Number 2. When the original record of the other case or any part of it is actually withdrawn from the archives at the court's discretion upon the request or with the consent of the parties and admitted as part of the record of the pending case. Jumamil versus Cafe, GR 144570. 3. When the present action is closely interrelated to another case pending between the same parties. Number 4. When the interests of the public in ascertaining the truth are of paramount importance. Number 5. In cases seeking to determine what is reasonable exercise of discretion or whether or not the previous ruling is acceptable in a case under consideration. Number 6. When there is finality of judgment in another case that was previously pending determination and therefore res judicata. Note, the exceptions are applicable only when the case is clearly referred to or the original or part thereof are actually withdrawn from the archives and admitted as part of the record of the case then pending. The appreciation of one judge of the testimony of a certain witness is not binding on another judge who heard the testimony of the same witness on the same matter. Each magistrate who hears the testimony of a witness is called upon to make his own appreciation of the evidence. It is therefore illogical to argue that because one judge made a conclusion in a certain way with respect to one or more of the accused, it is necessarily dictates that the succeeding judge who heard the same case against the other accused should automatically make the same conclusion. People versus Langit. Judicial notice of municipal ordinances. Inferior courts should take judicial notice of municipal or city ordinances in force in their territorial jurisdiction. A. MTCs are required to take judicial notice of the ordinances of the municipality or city wherein they sit. B. The RTC should take judicial notice of municipal ordinances only when 1. They are expressly authorized by statute. Number 2. On appeals of decisions by the inferior court when such courts had taken notice of a municipal ordinance. Letter C. Rules before appellate courts. 1. An appellate court is without authority to take into consideration the judicial records of a case previously decided by the trial court, upon which said court did not have the opportunity to pass. Number 2. An appellate court cannot consult the records in another case to ascertain a fact not shown by the records of the case before it, but could go to its other decisions for the law that is determinative of or applicable to the case under review. 3. The Supreme Court can also take judicial notice of its records in a previous case in connection with the conduct of litigant or witness in a similar matter. Number 4. Lower courts, from the CA down to the lowest level, must take judicial notice of decision of the Supreme Court, as they are in fact duty-bound to know the ruling of the High Tribunal and to apply them in the adjudication of cases, they being part of the legal system. Judicial notice of other matters. 1. The trial court can take judicial notice of the general increase in rentals or real estate, especially of business establishment. Katungal versus Howe, GR 134972. Number 2. A court cannot take judicial notice of an administrative regulation or a statute that is not yet effective. State Prosecutors versus Muro 236 KRA 505. 3. In the age of modern technology, the court may take judicial notice that business transactions may be made by individual through teleconferencing. However, there is no judicial notice that one was conducted in a particular case. Expert Travel and Tours versus Court of Appeals. Number 4. The court has likewise taken judicial notice of the Filipinas' inbred modesty and shyness and her antipathy in publicly arising acts which blemish her honor and virtue. Number 5. It is a matter of judicial knowledge that persons have killed or committed serious offenses for no reason at all. Pieper versus Sita. Judicial notice when necessary. Section 3. During the pre-trial and the trial, the court, motu proprio, or upon motion, shall hear the properties on the propriety of taking judicial notice of any matter. Before judgment or on appeal, the court motu proprio or upon motion may take judicial notice of any matter and shall hear the parties therein, if such matter is decisive of a material issue in the case. When hearing is necessary under the new rule, number 1, during pre-trial and trial, the court motu proprio or upon motion shall hear the parties on the propriety of taking judicial notice of any matter. Number 2, before judgment or on appeal, the court motu proprio or upon motion may take judicial notice of any matter and shall hear the parties thereon, if such matter is decisive of a material issue in the case. The purpose of hearing, not for the presentation of evidence, but to afford the parties reasonable opportunity to present information relevant to the propriety of taking such judicial notice or the tenor of the matter to be noticed. Mandatory judicial notice and discretionary judicial notice. Under mandatory judicial notice, court is compelled to take judicial notice. Under discretionary judicial notice, court is not compelled to take judicial notice. takes place at court's own initiative and in no hearing. Under the discretionary judicial notice, court is not compelled to take judicial notice. It is motu proprio or upon motion, and it needs hearing. In People versus Tundag, the court ruled that judicial notice of the age of the victim is improper, despite the defense counsel admission, therefore, acceding to the prosecution's motion. As required by Section 3 of Rule 129 as to any other matters such as age, a hearing is required before courts can take judicial notice of such fact. Judicial admission, Section 4. An admission, oral or written, made by the party in the course of the proceedings in the same case does not require proof. The admission may be contradicted only by showing that it was made through palpable mistake or that the imputed admission was not, in fact, made. Judicial admission is an admission, verbal or written, made by a party in the course of the proceedings. Elements: 1. The same must be made by a party to the case. 2. The admission must be made in the course of the proceedings in the same case. And 3. There is no particular form of an admission. It may be written or verbal. Judicial admissions versus extrajudicial admissions. Under judicial admissions, those made in the course of proceedings in the same case do not require proof and may be contradicted only by showing that it was made through palpable mistake or that no such admission was made. Judicial admission needs not be offered in the evidence since it is not evidence. It is superior to evidence and shall be considered by the court as established. It is conclusive upon the admitter, admissible even if self-serving, and it's subject to cross-examination. Under extrajudicial admission, those made out of court or in a judicial proceeding other than the one under consideration, regardless as evidence and must be offered as such, otherwise the court will not consider it in deciding the case. It requires formal offer for it to be considered. It is rebuttable. It is not admissible if serving, and it's not subject to cross-examination. Note: lack of jurisdiction over the subject matter cannot be admitted because jurisdiction over the subject matter is conferred by law and not by stipulation of parties. Judicial admissions may be made in 1. The pleadings filed by the parties. 2. In the course of the trial, either by verbal or written manifestations or stipulations. 3. In other stages of the judicial proceeding, as in the pre-trial of the case. 4th, admissions obtained through depositions, written interrogatories, or requests for admissions. Judicial admissions can be made by either a party or a counsel. Note 2 situations in criminal cases. 1. If it is a criminal case undergoing trial, the judicial admission by counsel can be received in evidence against the conformity of said defendant or even without his conformity. In the course of pre-trial conference, any admission must be reduced in writing and signed by both the defendant and her counsel before the admission can be received in evidence. That is under Rule 1118, Section 2. Remedy of a party who gave a judicial admission. 1. In case of a written judicial admission, motion to withdraw the pleadings, motion or other written instrument containing such admission. 2. In case of an oral judicial admission, counsel in open court may move for the exclusion of such admission. Remedies on amended pleadings. Admissions in superseded pleadings may be received in evidence against the pleader, Section 8, Rule 10. Such admissions are considered as extrajudicial admissions. The original pleading must be proved by a party who relies thereon by formally offering it in evidence. Torres versus CA. Judicial admissions are always conclusive upon the admitter and do not require formal offer as evidence, unlike the case of extrajudicial admissions. Facts alleged in a party's pleadings are deemed admissions of that party and are binding upon him, but this is not an absolute and inflexible rule. An answer is a mere statement of fact, which the party filing it expects to prove, but it is not evidence. Attilov the third versus CA. Rule on dismissed pleadings. Admissions made in pleadings that have been dismissed are merely extrajudicial admissions. Note, not all allegations or admissions in pleadings in civil cases may be considered as judicial admission because the rules on civil procedure allow a litigant to make hypothetical admissions in his pleadings, such as 1. When a defendant set up affirmative defenses in his or her answer, or when a defendant files a motion to dismiss based on lack of jurisdiction. Judicial admissions are made in one case are admissible at the trial of another case, provided they are proved and are pertinent to the issue involved in the latter, unless a. the said admission were made only for the purpose or purposes of the first case, as in the rule of implied admissions and their effects under Rule 26. B. The same were withdrawn with the permission of the court thereon, or 3. The court deems it proper to relieve the party therefrom. Rules on pleadings not filed. If signed by the party, the admission contained in the pleading is considered as an extrajudicial admission. Number 2. If signed by the attorney, it is not admissible. An attorney has authority to make statements on behalf of his client only in open court or in a pleading actually filed. Is the self serving rule applicable to judicial admissions? The answer is no. The self serving rule, which prohibits the admission or declaration of a witness in his favor, applies only to extrajudicial admissions. If the declaration is made in open court, such as raw evidence, and it is not self serving, it is admissible because the witness may be cross examined on that matter. However, whether it will be credible or not is a matter of appreciation on the part of the court. Are judicial admissions made by the accused during his arraignment binding upon him? The answer is no. A plea of guilty entered by the accused may be later withdrawn at any time before the judgment or conviction becomes final. Such plea is not admissible in evidence against the accused and is not even considered as an extrajudicial admission. Are admissions made during the pretrial in a civil case considered as judicial admissions? The answer is yes. Admissions made in the pretrial are deemed judicial admissions because they are made in the course of the proceedings of the case. Admissions in civil cases and admissions in criminal cases. In civil cases, admissions in a pleading which had been withdrawn or superseded by an amended pleading are considered extrajudicial admission. While under the criminal case, admissions during arraignment may be withdrawn at any time before the judgment of conviction becomes final, but such plea of guilty later withdrawn is not admissible in evidence against the accused who made the plea. It is not even considered an extrajudicial admission. What are the consequences of judicial admissions? 1. A party who judicially admits a fact cannot later challenge that facts as a judicial admission constitute waiver of proof. Production of evidence is dispensed with. Number 2. No evidence is needed to prove a judicial admission, and it cannot be contradicted unless it is shown to have been made through palpable mistake or that no such admission was made. Judicial admissions may be contradicted only when it is shown that 1. It was made through palpable mistake. Number 2. The imputed admission was not in fact made under the new rule. Rule 130, Rules of Admissibility, Section 1, Object as Evidence. Objects as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined, or reviewed by the court, rather viewed by the court. Object evidence is that which is addressed to the senses of the court. It is not limited to view of an object. It extends to visual, auditory, tactile, gustatory, and olfactory. Physical evidence is a mute but eloquent manifestation of truth. and it ranks high in our hierarchy of trustworthy evidence, where the physical evidence should prevail. Bank of the Philippine Islands versus Reyes. Object evidence is also known as real evidence, demonstrative evidence, autoptic preference, and physical evidence. Real evidence may be direct, can prove directly the facts for which it is offered. Example, in a personal injury case, the direct real evidence of disfiguring injury would be an exhibition to the court of the injury itself. Number two, circumstantial. Facts about the object are proved as the basis of an inference that other facts are true. Example, in a paternity case, a baby may be shown and asked to compare its appearance with that of the alleged father if they look alike. The court may then draw an inference that the parental relationship exists. Requisites of admissibility. Number one, the object must be relevant to the fact in issue. Two, the object must be authenticated before it is admitted. Number three, the object must not be hearsay. Number four, the object must not be privileged. And five, it must meet any additional requirements set by law. Example, it must not be the result of an illegal search and seizure. Authentication. To be admissible in evidence, the object sought to be offered must be shown to have been the very same thing in issue and is what it is claimed to be. Even though the object evidence may contain false information such as falsified books kept by the defendant, it is authentic insofar it is introduced by the prosecution for the purpose of showing falsity. Purpose of authentication: to prevent the introduction of an object different from the one testified about. Number two, to ensure that there has been no significant changes in the object's condition. Object evidence includes 1. Any article or object which may be known or perceived by the use of the senses. Number 2. Examination of the anatomy of a person or by any substance taken therefrom. Number 3. Conduct of tests, demonstrations, or experiments. And 4. Examination of representative portrayals of the object in question. Example, maps, diagrams. Categories of object evidence. For purposes of authentication of an object evidence may be classified into 1. Unique objects, objects that have readily identifiable marks. Example, a caliber .38 revolver with a serial number. 2. Objects made unique are objects that are made readily identifiable, like typical kitchen knife, which the witness can readily identify in court if he claims that he made the thing acquire a unique characteristic by placing identifying marks thereon. Number 3, non-unique objects. These are objects with no identifying marks and cannot be marked. Example, drops of blood or drugs in powder form. Under the third category, the opponent of the evidence must establish a claim of custody. The links to the chain are the people who actually handled or had custody of the object. Each of them must show how he received the object, how he handled it to prevent substitution, and how it was transferred to another. Chain of custody in drug related cases. Chain of custody means the duly recorded authorized movements and custody of seized drugs or controlled chemicals or plant sources of dangerous drugs or laboratory equipment of each stage, from the time of seizure or confiscation to receipt in the forensic laboratory to safekeeping to presentation in court to destruction. Such record of movements and custody of seized item shall include the identity and signature of the person who held temporary custody of the seized item, the date and time when such transfer of safekeeping and used in court as evidence, and final disposition. Section 1 DDB Regulation Number 1 Series of 2002. The existence of the drug is the very corpus delicti of the crime of illegal possession of dangerous drugs, and thus a condition sine qua non for conviction. In order to establish the existence of the drug, its chain of custody must be sufficiently established. The chain of custody requirement is essential to ensure that doubts regarding the identity of the evidence are removed through the monitoring and tracking of the movements of the seized drugs from the accused to the police, to the forensic chemist, and finally to the court. People versus Martinez. Question: when is there a need to establish a chain of custody? Answer: it is necessary when the object evidence is non unique, as it is not readily identifiable, was not made identifiable, or cannot be made identifiable. Example: drops of blood or oil, drugs in powder form, fiber, grains of sand, and similar objects. What is the purpose of establishing a chain of custody? Answer: to guarantee the integrity of the physical evidence and to prevent the introduction of evidence which is not authentic, but where the exhibit is positively identified, the chain of custody of physical evidence is irrelevant. Photographs. Photographs, when presented in evidence, must be identified by the photographer as to its production and testified as to the circumstances under which they were produced. The value of this kind of evidence lies in its being a correct representation or reproduction of the original, and its admissibility is determined by its accuracy in portraying the scene at the time of the crime. The photographer, however, is not the only witness who can identify the pictures he has taken. The correctness of the photograph as a faithful representation of the object portrayed can be proved prima facie, either by the testimony of the person who made it or by other competent witness who can testify to its exactness and accuracy, after which the court can admit it subject to impeachment to its accuracy. Season versus people. Demonstrative evidence, real evidence versus demonstrative evidence. Under real evidence, tangible object that played some actual role in the matter that gave rise to the litigation intends to prove that the object is used in the underlying event. Under demonstrative evidence, tangible evidence that merely illustrates a matter of importance in the litigation intends to show that the demonstrative object fairly represents or illustrates what it is alleged to be illustrated. Ocular inspection or view. The court can go to the place where the object is located when the object evidence cannot be brought to the court because it is immovable or inconvenient to remove. View is part of trial. The inspection or view outside the courtroom is a part of the trial. Inasmuch as evidence is thereby being received, such inspection should be made in the presence of the parties or at least with previous notice to them of the time the place set for the view. Real evidence, tangible object that played some actual role in the matter that gave rise to the litigation. Demonstrative evidence, these are tangible evidence that merely illustrates a matter of importance in the litigation. Limitations against the use of real evidence may be classified into 1. Inherent limitations. When the object is irrelevant to the fact in issue, it may be exhibited to, examined, or viewed by the court, thus it excludes the following: irrelevant evidence, be illegally obtained evidence. Number 2, non-inherent limitations. Relevant evidence may be excluded on the ground that although relevant and authentic, its probative value is exceeded by its prejudicial effects, such as the following: A. Indecency and impropriety. Its exhibition is contrary to public morals or decency. Letter B. Undue prejudice. C. Offensiveness to sensibilities. D. Inconvenience and unnecessary expenses. To require its being viewed in court or in ocular inspection would result in delays, inconvenience, or unnecessary expenses which are out of proportion to the evidentiary value of such object. No, but when the exhibition is necessary to the ends of justice, notions of decency and delicacy, of feelings, will not be allowed to prevail. The Book of Herrera, Remedial Law, Book 6, 1999. Documentary Evidence, Section 2. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray films, motion pictures, or videos. So documentary evidence consists of WR, POW, W, writings, R, recordings, P, photographs, A, any material containing letters, words, sounds, etc., and O, other modes of written expression. Note, under the rules on electronic evidence, audio, photographic, and video evidence are under Rule 11, separate from the definition of an electronic document. Under Rule 3 thereof, with the amendment, it is clear that the photographic, video, and audio evidence are not electronic documents, but rather simply documentary evidence. Purpose to prove the contents of the writing. If offered for some other purpose, the writing or materials would not be deemed documentary evidence, but merely object evidence. Illustration. A photocopy of the marked bills used in a buy-bust operation is considered object evidence if it was presented to prove that money actually exchanged hands in the buy-bust operation. However, if the purpose of such a presentation is to prove writings or contents on the bills, then it is to be considered as documentary evidence subject to the best evidence rule. Procedure on how to present documentary evidence before the court. It should be authenticated and proved in the manner provided in the rules of court. Number 2, it should be identified and marked. Number 3, it should be formally offered to the court and shown to the opposing party so that the latter may have the opportunity to object thereto. Requisites for admissibility, Raul. 1. The document must be relevant. Letter B. The evidence must be authenticated. C. The document must be authenticated by a competent witness. And D. The document must be formally offered in evidence. Bar 2005 question. May a private document be offered and admitted in evidence both as documentary evidence and as object evidence? The answer is a private document may be offered and admitted as documentary evidence and as object evidence depending on the purpose of which the document was offered. If offered to prove its existence, condition, or for any purpose other than the contents of a document, the same is considered as object evidence. When the private document is offered as proof of its contents, the same is considered as a documentary evidence. Section 2, Rule 130, Rules of Court. The document may be offered for both purposes under the principle of multiple admissibility. Original content or best evidence rule. Section 3. When the subject of inquiry is the contents of a document, writing, recording, photograph, or other record, no evidence is admissible other than the original document itself, except in the following cases. A. When the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. B. When the original is in the custody of or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. Letter C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. D. When the original is a public record in the custody of a public officer or is recorded in a public office, and E. When the original is not closely related to a controlling issue. Original document rule states that when the subject of inquiry is the contents of a document, writing, recording, photograph, or other records, no evidence such as a reproduction, photocopy, or oral evidence is admissible other than the original document itself. Best evidence rule. Rule a misnomer. The term was changed as it has nothing to do with the degree of its probative value in relation to other types of evidentiary rules. It is not intended to mean the most superior evidence. More accurately, it is the original document rule or the primary evidence rule. Purpose: to prevent and to detect fraud, to exclude uncertainties in the content of a document. General rule: the original writing must be produced and provided. Exceptions: 1. When the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. When the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. Number 3. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the facts sought to be established from them is only the general result of the whole. 4. When the original is a public record in the custody of a public officer or is recorded in a public office. And 5th, when the original is not closely related to the controlling issue. Revised Rules on Evidence. Rule 130. Note: non-production of an original document unless falling within the exceptions under Section 3 of Rule 130 will give rise to the presumption of suppression of evidence adverse to the party who withholds it. Applicability: the best evidence rule applies only when the terms of a written document are the subject of the inquiry. In an action for quieting of title based on the existence of a deed of sale with right to repurchase that purportedly casts a cloud on the title of a property, therefore the best evidence rule does not apply, and the defendant is not precluded from presenting evidence other than the original document. Ears of Proudhon versus Ears of Alvarez. There is no reason to apply the best evidence rule when the issue does not involve the contents of a writing. Where the issue is only as to whether or not such document was actually executed or exists, or in the circumstances relevant to or surrounding its execution, the best evidence rule does not apply, and testimonial evidence is admissible. In this case, the marked money was presented by the prosecution solely for the purpose of establishing its existence and not its content. Therefore, other substitute evidence, like a Xerox copy thereof, is admissible without the need of accounting for the original. Flores de Leon versus People. Requisites: the subject matter must involve a document, and B. The subject of the inquiry is the contents of the document. Waiver of the rule: mere photocopies of documents are inadmissible pursuant to the best evidence rule. Nevertheless, evidence not objected to is deemed admitted and may be validly considered by the court in arriving at its judgment. Courts are not precluded to accept in evidence a mere photocopy of a document when no objection was raised when it was formally offered. When document is merely collaterally in issue. A document is collaterally in issue when the purpose of introduction or introducing the document is not to establish its terms but to show facts that have no reference to its contents, like its existence, condition, execution, or delivery. In this case, the best evidence rule does not apply. When original documentary evidence is not closely related to a controlling issue in the case, there is no need to produce the original of an irrelevant document where such document or evidence was nevertheless admitted in evidence. Note: evidence, in order to be admissible, must be relevant in certain situations such as lack of objection or admitted by the court. Best evidence rule in criminal cases. 1. Falsification of document. It is indispensable that the judge have before him the document alleged to have been simulated, counterfeited, or falsified in order that he may find, pursuant to the evidence produced at trial, whether or not the crime of falsification is actually committed. U.S. versus Gregorio, GR 5791. Libel. Number 2. Libel based on defamatory article. The newspaper containing said article is the best evidence. Fiscal versus Reyes. Question: when a photocopy of a certain document is presented, is it automatically excluded because of the best evidence rule? The answer is no. If the presentation of the photocopied document is only for the purpose of proving the existence, execution, or the delivery of the said photocopied document without any reference to it terms, such evidence may still be admissible. Under the best evidence rule, the original document must be produced, whether its contents are the subject of inquiry. A photocopy being mere secondary evidence is not admissible unless it is shown that the original is unavailable. Before a party is allowed to adduce secondary evidence to prove the contents of the original, the offerer must prove the following: 1. The existence or due execution of the original. Number 2. The loss and destruction of the original or the reason for its non production in court. And 3. On the part of the offerer, the absence of bad faith to which the unavailability of the original can be attributed. The correct order of proof is as follows: existence, execution, loss, and contents. EELC. Question: when the original of a document is presented, is it automatically admitted? The answer is no. It has to undergo the process of authentication, except if the document is a public document. Section 4. Original of document. An original of a document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of a photocopy includes the negative or any print therefrom. If data is stored in a computer or similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is an original. B. A duplicate is a counterpart produced by the same impression as the original, or from the same matrix, or by means of photography, including enlargements and miniatures, or by mechanical or electronic re recording, or by chemical reproduction, or by other equivalent techniques which accurately reproduce the original. C. A duplicate is admissible to the same extent as an original unless 1. A genuine question is raised as the authenticity of the original, or 2. In the circumstances, it is unjust or inequitable to admit the duplicate in lieu of the original. Original document is a document itself or any counterpart intended to have the same effect by a person executing or issuing it. Original photograph includes the negative or any print therefrom. If the data is stored in a computer or similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is an original. Note, however, while the definition adopted the phrasing of an original of an electronic document, it appears that the definition of a document under the revised rules does not contemplate an electronic document. This is because under Section 1, letter H of the Rules on Electronic Evidence, the electronic document refers to those that are received, recorded, transmitted, stored, processed, retrieved, or produced electronically. The revised rule only states that if the document or data is stored in a computer or other similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is considered as its original. Before secondary evidence can be presented, all duplicates and or counterparts must be accounted for, and no excuse for the non-production of the original document itself can be regarded as established until all parts are unavailable. Reason: all the duplicates or multiplicates are parts of the writing itself to be proved. Document amended or altered by the parties. Where the document, duplicate, or a copy is amended or altered by the party or parties, it becomes the original. Rule on duplicate original. A duplicate is a counterpart produced by the same impression as the original, or from the same matrix, or by means of photography, including enlargements and miniatures, or by mechanical or electronic re recording, or by chemical reproduction, or by other equivalent techniques which accurately produce the original. However, in the instant case, contrary to petitioner's contention, the receipt presented by SMP is deemed as an original, considering that the triplicate copy of the provisional receipt was executed at the same time as the other copies of the same receipt involving the same transaction. BPI versus SMP GR 175466. The transcripts of stenographic notes, or TSNs, clearly show that Chewy convincingly explained that CSFL usually prepared two copies of invoices for a particular transaction, giving one copy to a client and retaining the other copy. The court combed through her testimony and found nothing that would indicate that the documents offered were mere photocopies. She remained firm and consistent with her statement that the subject invoices were duplicate originals as they were prepared at the same time. The court sees no reason why Section 4, letter B, Rule 130 of the Rules of Court should not apply. Capital Shoes versus Traveler's Kid, GR 2065, 2014. Note, under the amendment, the phrase duplicate is a counterpart produced by the same impression as the original may still encompass the definition under the original paragraph. Illustration: a duplicate produced by photography, such as, for instance, a screenshot, is still considered the original, given that by definition, a photograph is documentary evidence. Number two, an enlargement of an X ray film, for instance, is considered the duplicate thereof and hence the original. Number three, an electronic re recording can pertain to a re recorded audio or video, such as CCTV footage. Note, however, consistent with the ruling in National Power Corporation versus Godilla Jr., GR 170491, a reproduction of a paper-based document with the use of a photocopy machine would not make the copy produced thereby an original document. It is still secondary to the original paper-based that was photocopied, similar to MCC Industrial Sales Corporation versus Sangyong Corporation. It was held that the facsimile copy is not an original but secondary evidence, there being a paper-based original thereof. Duplicates shall not be admissible as original if QU 1. A genuine question is raised as to the authenticity of the original. 2. In the circumstances, it is unjust or equitable to admit the duplicate in lieu of the original. Deletion of the old paragraph, letter C. It appears that an entry repeated in the regular course of business, one being copied from another or near the time of the transaction, is no longer considered an original unless it may be argued to fall under the definition of a counterpart produced by the same impression as the original or from the same matrix, among others. Secondary evidence, Section 5. When original document is unavailable. When the original document has been lost or destroyed or cannot be produced in court, the offerer, upon proof of its execution or existence and the cause of its unavailability without bad faith on his or her part, may prove its contents by a copy or by recital of its contents in some authentic document or by the testimony of witnesses in the order stated. When the original document has been lost or destroyed or cannot be produced in court, the offerer, upon proof of its execution or existence and the cause of its unavailability without bad faith on his or her part, may prove its contents by court, CORT, by a copy, by a recital of its contents in some authentic document, by the testimony of witnesses, and note, the order must be followed, CRT. Predicates of secondary evidence. The offerer of the secondary evidence is burdened to prove satisfactorily the predicates thereof, namely BOLD. Unavailability of the original is not due to bad faith on the part of the proponent or offerer. Execution, letter E, or existence of the original, and L, loss and destruction of the original of its non-production in court, and D, proof of the due execution of the document and its subsequent loss would constitute the basis for the introduction of secondary evidence. Dantes versus Maghinang Jr. The original must be duly shown to be unavailable. A photocopy, being a mere secondary evidence, is not admissible unless it is shown that the original is unavailable. In the case at bar, Lagman mentioned during the direct examination that there are actually 4 duplicate originals of the 1990 bond. The first is kept by the NFA, the second is with the loan officer of the NFA in Tarlac, the third is with country bankers, and the fourth was in his possession. Despite knowledge of the existence and whereabouts of these duplicate originals, Lagman merely presented a photocopy. He admitted that he kept a copy of the 1990 bond, but he could no longer produce it because he had already severed his ties with country bankers. However, he did not explain why severance of ties is by itself reason enough for the non-availability of his copy of the bond, considering that it appears from the 1989 bonds, Lagman himself a bondsman. Country bankers versus Lagman. Rule: when more than one copy exists, when more than one original exists, it must appear that all of them have been lost, destroyed, or cannot be produced in court before secondary evidence can be given of any one. A photocopy may not be used without accounting for the other original. Citibank versus Judicial. When opponent does not dispute contents. When production of the original may be dispensed with in the trial court's discretion whenever the opponent does not bona fide dispute the contents of the documents and no other useful purpose will be served by requiring production. Gao versus Chua. Order of proof. The correct order of proof is as follows: EELC, existence, execution, loss, and content. Note, the order may however be changed if necessary at the discretion of the court. The sufficiency of the proof offered as a predicate for the admission of an allegedly lost document lies within the judicial discretion of the trial court under all the circumstances of the particular case. In fine, the Mateos have not satisfactorily shown that the original of the TCT has been lost or is no longer available. Republic versus Spouses Mateo. The execution and authenticity of the document must be proved by any person. E. Casa. 1. Who executed the document? 2. To whom the parties to the instrument had previously confessed the execution thereof. 3. Before whom its execution was acknowledged. 4. Who was present and saw it executed and delivered. 5. Who, after its execution and delivery, saw it and recognized the signatures. E. Michael and Company versus Enriquez. B. The loss or destruction of a document may be proved by KEI. 1. Any person who knew the facts of loss. 2. Anyone who has made a sufficient examination in the place or places where the document or papers of similar character are usually kept by the person in whose custody the document lost, was, and has been unable to find it. 3. Anyone who has made investigation which is sufficient to satisfy the court that the instrument is indeed lost. It is not necessary to prove the loss of the original document beyond all possibility of mistake. A reasonable probability of its loss is sufficient, and this may be shown by a bona fide and diligent search fruitlessly made, for it is in places where it is likely to be found. Note, proof of loss of the original document may be dispensed with where both the parties admit that an instrument has been lost. The contents of an instrument may be proved against the party by his admission in writing without accounting for non-production of the original document. C. The contents of a document may be proven by any person who, SRHPC, 1. Signed the document, 2. Read it, 3. Who heard it being read, knowing or it being proved from other sources that the document so read was the one in question. 4. Was present when the contents of the document were talked over between the parties thereto to such extent as to give him reasonably full information as to its contents. And 5. To whom the parties to the instrument have confessed or stated the contents thereof. E. Michael and Company versus Enriquez. Note, secondary evidence of the contents of a writing cannot be introduced where it appears that the writing, if produced, would not be admissible even if its absence is satisfactorily explained. If the fact to which the writing relates can be proved independently of the writing, it may be proved by parole evidence even though the writing, if produced, could not be received as evidence of the fact. Section 6. When original document is in adverse party's custody or control. If the document is in the custody or under the control of the adverse party, he or she must have a reasonable notice to produce it. If after such notice and after satisfactory proof of its existence, he or she fails to produce the document, secondary evidence may be presented as in the case of its loss. Requisites 1. Opponent's possession of the original. P. Reasonable notice to opponent to produce the original. N. 3. Satisfactory proof of its existence. And F. Failure or refusal of opponent to produce the original in court. Admission of secondary evidence. The mere fact that the original of the writing is in the custody or control of the party against whom it is offered does not warrant the admission of secondary evidence. The offerer must prove that he has done all in his power to secure the best evidence by giving notice to the said party to produce the document. When such party has the original of the writing and does not voluntarily offer to produce it, or refuses to produce it, secondary evidence may be admitted. Magdaya versus People, GR 152881. Certified Xerox copies admissible. The certified Xerox copies of the marriage contracts, issued by a public officer in custody thereof, are admissible as the best evidence of their contents, as provided for under Section 7 of Rule 130. The certified Xerox copies should be accorded the full faith and credence given to public documents. Bunagan Bansig versus Silera. Rule on public documents. While the LC map may be considered a public document and prima facie evidence of the facts stated therein, the map, to be admissible for any purpose, must be evidenced by an official publication thereof, or by a copy attested by the officer having legal custody of the records. The rules on admissibility must be applied uniformly. The same rule holds true when the government is one of the parties. Saad Agroindustries versus Republic. No particular form for certification. The rules does not require that the certification should be in a particular form. The 4-page resolution dated December 8, 1997 contains a stamped certification signed by Police Inspector David Ursua of the Legal Service, PNP Regional Office 1 of Parian, San Fernando, La Union. The 3-page decision dated February 28, 1997 has the handwritten authentication of Police Inspector Mario Aduan, also from the same office, on each and every page. They ought to satisfy the requirement of the rules on certification. Kabugao, E. Season versus People. Affidavits. While affidavits may be considered as public documents if they are acknowledged before a notary public, these affidavits are still classified as hearsay evidence. The reason for this rule is that they are not generally prepared affiant, but by another one who uses his or her own language in writing the affiant's statement, part of which may thus be either omitted or misunderstood by the one writing them. Moreover, the adverse party is deprived of the opportunity to cross-examine the affiant. For this reason, affidavits are generally rejected for being hearsay, unless the affiants themselves are placed on the witness stand to testify thereon. Irremovability of public records. Any public record, an official copy of which is admissible in evidence, must not be removed from the office in which it is kept, except upon order of a court, where the inspection of the record is essential to the just determination of a pending case.